Good afternoon. It's me, Tracy B. I am back. I am back. I am back. I am back. I've been gone for a little while. We had an unexpected death of a loved one, so I needed some time to go through a lot of stuff. But I'm back now. I am not 100%, but I am. I missed doing my lives, my videos, my chatting with my people. Um, so this is my first time connecting with you guys since the end of January, I think. Wow. I think I took the whole month of February off. Well, it's a new month. It's March, um, the third month in what I hope to be a better year than last year. Although this one didn't get off to a great start either. But hey, we have to, play the hand we're dealt, right? So anyway, today's Thick of It Thursdays. As some of you, if not all of you know, I do this every single Thursday on my Facebook business page, The Divorce Solutionist, and in my group, The Divorce Glow Up, and on my YouTube channel, The Divorce Solutionist on YouTube. I go live every single Thursday at 4 p.m. Eastern Standard Time to discuss a topic that has to do with divorce and or custody specifically. Sometimes I'll deviate and do a little bit about child support or um, something else, child protective services, abuse neglect cases, or things like that. But my main focus is divorce and custody. Anything related to the two is what I mainly focus on. So today, in alignment with that, I am going to talk about parenting agreements because I see that's a topic that comes up way, 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 way too often. And I say too often because it's sometimes it's parenting agreements are not complicated, but they're not standard either, if that makes any sense. So they're not complicated in a sense where every single state has an idea of what they want in parenting agreements, and they all are principled on the same basis, and that is what's best for the child or the children. And so that's what I mean by it's not complicated, but it's not generalized either because each state, although they pretty much have the same principles, how they actually spell those out or set those factors out may differ a little bit. But with respect to parenting agreements or orders or plans, that may differ from state to state because of things like procedure and basically, yeah, procedure. That's usually how they differ significantly. One example is there are states who, when you file for custody, you have, and divorce, I think, when you're in the divorce action, when you're asking for custody, or if the party's never been married and they're seeking custody, some states require that a parenting plan or parenting order be submitted with the documents. I think Utah is one of those states where you have to submit a proposed, what they call a proposed order. Proposed meaning you've come up with an idea. You and the other parent came up with an idea of what you want the schedule to look like, and so you submit that to the court so that the court can review it and sign off on it. So there are some states that I know Utah does it. I think that there's quite a few. I was trying to actually get some information as to how many states actually do have that requirement, and I wasn't. There was no one resource to find that. So when I get some free time, whenever that is, I will take the time to actually go through the states to not only discern which ones have that requirement, but which ones have requirement as far as parenting education and things like that. So that I will have that so that in the event questions are asked regarding that, I could I could have that answer already. But that's going to take a little bit of time because, like I said, I tried to research it today and there was just no one source. I would have to go through each state um, or get my assistant to do that, to go through each state and find out what their specific requirements are. But what is a parenting agreement or custody agreement or co-parenting agreement? There's so many names they're used. Parenting plan. A parenting plan, agreement, custody agreement, co-parenting agreement is just that. It's just an agreement, usually an informal one, but sometimes a formal one, depending on how it became to be formal, that parties, the parents have come up with regarding visits with the other parent with regarding the kids. It usually covers pick up and drop off, what's to happen during the parenting time, communication during parenting time, and things like that. The one thing I wanted to stress before I forget is that a few people have asked me, were parenting agreements enforceable? Um, Informal parenting agreements, were they enforceable? And when I say informal, I mean an agreement that, because parents can come up with an agreement on their own, verbally or written. They can come up with an agreement on their own. That's fine. You don't have to have courts involvement to do that. Some parents do that with just the support or the help of a parenting coordinator. There are places where parents just go to a parenting coordinator and they help them come up with a parenting agreement, and there's no court involved. There are parenting coaches who help parents come up with an agreement regarding custody of the kids or visits for the kids with their parents, the other parents, and there's no court involved. So that's a pretty informal agreement. And I say informal because it's not something a mediator or a court-ordered mediator or a judge got involved with. So, and that's just my way of distinguishing them. That's not across the board. That's just how I distinguish them. So, and so the question was asked recently multiple times: are those enforceable? And they're not necessarily enforceable if they were made, like I said, amongst the parents or with the assistance of a coach or a parenting coordinator, because they're not under the guise of the court. They weren't court ordered. So they're not necessarily enforceable, because the only orders that are enforceable are court orders. However, if there's an agreement and for some reason one or both of the parties decide to deviate from it, or they're not satisfied with it anymore, and either one of them decide to go to court, and they file an initial petition, the first petition in court for custody or visits or whatever, that agreement, that informal agreement, it can be used. Either party can actually present that to the court and say, hey, listen, judge, this is something we've been doing for this long, and this is where we were until we hit an impasse for whatever reason. And believe it or not, most judges want to see those, because anytime you can make the judge's workload less, and anytime you can show the court that you were actually at a point where you can co-parent and agree on things without the assistance of the court, they actually absolutely love that. They love that. So you'd be hard pressed to find a judge who just doesn't want to see that and will completely disregard it, unless it's against public policy. And you're always going to hear me say against public policy, because that's the way most of us know whether or not an agreement, especially regarding kids, is going to be something that the court is going to look at. An informal agreement, is something the court is going to look at, because public policy is it's like it's basically like going against standards. There are standards within the family law community, and if you come up with an agreement that goes against those basic standards, then it goes against public policy. And the public has an interest in parents having the right to parent their kids the way they see fit, as long as it doesn't interfere with other social norms or mores, or deviate from those social norms or mores. So yeah. So a judge can't say to the violating parent, oh, you have to comply with that agreement because you came up with it. No, they're not going to do that. What they would do is they would decide if that agreement will serve as the basis for the court order, and they will actually they will incorporate it, or they will modify it, or they will extend upon it, but they will not just use that agreement as their order to enforce it against the other party, if that makes any sense. So like for instance, Mary and Peter came up with an agreement on their own. And Mary decides that it doesn't work anymore because they made the agreement when their kids were 2 and 3. Now the kids are 8 and 9. So Mary decides to take Peter to court for custody and visitation. And they get to court, and Peter says, "Hey, Judge, I don't want to deviate from the, we already had an agreement. I don't want to deviate from it. It works for me." And he says, "Here, this is the agreement that we've been working on for the last 6-7 years. And this is what I want to stick by. I want you to enforce it. I want you to make her comply with this agreement." So the court may say, "Okay, well, let me look at it. And if, the provisions meet all the guidelines for that particular court's best interest factors, then they will, pretty it up, doctor it up, and incorporate it." Incorporate it means the judge will come up with its own order and decide to use whichever provision it thinks are still applicable in your case from that specific informal agreement. They won't say, "Mary, you have to abide by that agreement that you guys came up with because you did it on your own," and blah. No, they're going to make a new order. They're gonna make a parenting agreement order, or a co-parenting agreement order, or a parenting plan order. Notice I'm saying order. Order is when the judge decides to make it his or her own, with putting their signature on it. Now it's a court order. Now that's what can be enforced. They can't enforce an order that's not, that wasn't devised by the court. They will enforce a court order. So there is a difference. Or if it was the similar situations, no. It's different if the order, the agreement or the parenting plan was devised with the assistance of a mediator, especially if it's a court-ordered mediator. In most cases, in most states where there's a court-ordered mediator involved, whatever that mediator came up with, the court will defer to it 100%. There's some courts that don't sign off on mediated agreements. So let me just make that clear. And what I mean is the judge does not sign off on it. So if the judge does not sign off on a mediated agreement, even if it was court ordered, then it's not a court ordered an agreement. So they won't necessarily, it's still modifiable, but not necessarily enforceable. Again, because it's not a court ordered mediated agreement. If it's so ordered by the court, meaning the mediated agreement was done by the court-ordered mediator, and the judge decides to sign off on it, whatever the procedure is in your particular state, if the judge signs off on it, then yeah, now it's a court order. It's a court-ordered mediated agreement. That's a lot. Tongue tie. And that is a little different than just a mediated agreement. But a mediated agreement will get, especially court-ordered, because some mediated agreements are not court-ordered. Some courts have a requirement that parents go to mediation before they actually get to a judge. And in that case, most of the time, the judge will defer to that court-ordered mediated agreement, whether the judge so ordered it or not. Okay? I don't want to overwhelm you or confuse you. If you have a question about your specific state, please feel free to ask me in the comments, and I'll try to answer what applies to your specific state. Let me just say this, because I don't know if I've ever said this, but everything I talk about only applies to the United States. I don't know anything about Canada or Mexico or anything else, anywhere else but the United States. And I have what I know about the 50 states is because I do a lot of I do a lot of work on a nationwide basis. I had to think of the word. I'm sorry, it's been so long. Gotta relax. Anyway, so now that you know what a parenting agreement is, a co-parenting agreement, custody agreement, uh, whatever you want to call it. I want to talk about some of the provisions that should be included in parenting agreements. And I want to pull one up real quick. Um, so when I was in practice, I'm trying to think. As yeah, we did parenting agreements often, but it wasn't very formal. I'm trying to remember if the court had their own forms. That's another thing. Some courts have their own forms. Some states have their own forms where you can go to the state's website and you can download a parenting plan, whether PDF, Word, or whatever, and that's what the courts prefer you use. I don't remember New York having that though. I don't remember New York having a specific form on their website, but I know a lot of states do. And I was trying to remember. I think I just devised my own. I think I always had a template for them. But anyway, and I bring that up while you ask me. So I bring it up. I bring it up because some provisions are pretty standard, pretty across the board in parenting agreements. And let me just distinguish parenting agreements or co-parenting agreements with parallel parenting agreements. That's something entirely, well, not entirely different, but the objective is different. Parallel parenting agreements are for when the parties don't get along, don't communicate. There's a history of DV or any sort of abuse or toxicity, and they have to parent their kids on a parallel, like separately. So two households, two set of rules, two set of everything. So that's different. So I'm not going to talk about those. I'm only talking about pretty standard parenting agreements. Um, so I want to go through some of the uh, standard provisions that are included in parenting agreements. So one of the provisions that's usually included is phone contact and video contact. Um, that's something, and it's definitely something that I noticed that a lot of people get really peeved about when it's not specific. I mean, they get peeved about it for other reasons anyway, even if it is included. But if it's not included, especially with younger kids, when there's no provision about phone or video contact with when the kids are in the other parent's custody, it it creates a lot of dissension because if you're used to having your kids all the time, and then they spend every other weekend with dad or mom, and during that 3-day weekend or 2-day weekend they have no contact with you. That can get a little touchy, you know so if you're one of those parents that needs to have that communication, that continuum of communication, then you need to make sure that there's a provision in the agreement regarding reasonable telephone and video contact. Older kids usually have a cell phone where they could do that on their own. If there is a problem with the other parent controlling use of the cell phone, then you need to specify that in the agreement as well. It needs to be clear that if there are rules in the other household that the kids are not to have the phone during that visit, then you need to specify during which day, which specific period of time will the child be able to have access to a phone or a computer or a laptop or tablet or whatever, just to have phone contact with the other parent. You need to be as specific as possible. I prefer, I mean, most agreements usually say reasonable contact. No, I wouldn't leave it at that. I would be as specific as possible to day, time, and how long of a window should remain open. What I mean by that is to say, okay, Saturday night, little Bobby is to have access to the phone, so he can receive my phone call from the hours of 7 p.m. to 8 p.m. The whole window should be open and available so that I can have contact with my child. Now, you don't have to actually use the whole hour, because depending on the age of the kid, that's a little bit to expect for a kid to sit on the phone for a whole hour, even if it's a video. I know my son is 8, and his attention span is short. He's not sitting on a phone or video chat for an hour. He's not even doing it for 20 minutes. So if you know your kid, then use a reasonable amount of time if you're going to narrow down the window to how long that phone call should last, at least. Another provision is that should be included is who should pick up and drop off, location, time, lateness, who can be present. All of those things should be included, and they should be as specific as possible when you've had a history of things or issues with those particular topics. It's pretty tricky, and I'm going to tell you this. Sometimes too many details create havoc, and all it does is create more and more opportunities for the other side to bring you back to court for contempt or violation of um, of the agreement. So it's a tricky proposition to get really, really nitpicky and too controlling and too detailed and too specific about every little thing. But those things are important. Pick up and drop off time. How long should the either parent wait for the other? Who should attend if there's a history of conflict with either parent's new spouse or new mates or boyfriend, girlfriend, whoever. And what was the other thing I said? Location. Those should be very, very specific. Okay. Anything else about, what should they bring and blah, 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 that, if you want, you can include that as well. But, those 4 things are the main things that should be included. Extracurricular activities. Now, that's a good one, too, because not a lot, but I do see, especially as kids get older and they become involved in sports and, all that stuff, it becomes really tricky when every single Saturday, little Johnny has soccer practice, but he's on dad's time 2 Saturdays out of the month. Should dad be obligated to take little Johnny to his soccer practice on his days when he's the non-custodial parent? Well, you know what? If it's me personally, I think so. I think if little Johnny is involved in soccer, little Johnny loves soccer, little Johnny is at risk from being kicked off the team or out of the club or whatever they call them because he doesn't attend every Saturday like he should, then yes, dad should be obligated to take him. If that is the case and dad just can't, then maybe working around dad's schedule would work best. In other words, maybe little Johnny can go to dad after soccer practice instead of during that time. But that should definitely be included. You should not expect the other parent to transport the kids to their extracurricular activities just because you think that's what parents are supposed to do. Right, wrong, or indifferent, start from that premise and you'll be better off, because judges fluctuate with that. And they look at it in a totality of circumstances. They look at everything. If it's a varsity team, of course, that's going to be more important. If it's just something that Johnny does and he's 2 or he's 3 and all they're doing is kicking around a ball and he has 3 other activities he goes to during the week that's similar, that may not be dad's responsibility to take him to that. So again, you can include it, you can try to negotiate that, but it should definitely be addressed. It should definitely, whatever you decide, it should definitely be addressed and included in the as one of the provisions. At the same token, and this came up in a group, someone asked, if there's a death in the family or an emergent or like at a big event and it's not on my time, should the other parent be obligated to bring the child to me so that they can accompany me to this special event or death or whatever? And the answer is no. That's not an automatic. Again, if that's what you want, if both parents can agree, then you should definitely include that in your parenting plan. You can include that. You can definitely address that, but it's not. Sometimes parents think because they operated a certain way when they lived in the same household or when they were together, they think that that's supposed to continue on once they've split, once the family is split up. And it doesn't work that way because now both parents have, different lives. Some of them have new partners. Some of them have new partners and new kids. So things change. So, yeah, the way you parent is going to change. The way you share responsibilities is going to change. And if some things or some things are important to both of you, then start there. Start from that basis, from that standpoint. Let's address the things that we both agree on first, that we know are important to both of us. And then you start to build from there. But don't expect, because you think it's the morally correct thing or right thing to do, don't expect the other parent to say, yes, sure, here, you can take the kids to your emergency event or your death in the family on my time. No, they're not wrong. They may be morally wrong, but if there's nothing in your parenting plan, your court, or especially a court ordered parenting plan, then no, that's not something that they have to do. Again, if your judge decides, hey, well, you should have let him go, you should have let them go, then you may not ever know that until it's brought up in court. The thing is, while that emergency event is going on, no one's going to force him or her to bring the kids to you. So by the time you file a violation or modification or enforcement or contempt, whatever you file, that event has passed. So you can only talk about it prospectively. And that's a good time to bring up, if you decide to take her to court for something else, that's a good time to bring up that happened so that the judge can give you some idea of how they would rule on something like that, or what you should include in the agreement from this point on. But until then, no, they don't have to comply. They don't have to oblige you, but include it in the agreement. Include it in the agreement. Another major provision that I see asked about often is the right of first refusal. I'm not going to go through all of the factors today, all of the provisions today, because there's a lot. But I'm going to go through maybe two more, and then I'm going to see if I have any comments and answer those comments. But the right of first refusal. The right of first refusal usually says when the kids are in the non-custodial parents or the custodial parents' custody, and something comes up where they can't continue visits or custody or parenting time with the kids, who is supposed to get the kids? Does the parent who has the kids have the right and the obligation to get one of their family members to help out or a babysitter to help out? Or should they first contact the co-parent and see if the co-parent wants to take over, to pick up custody or visitation at that particular time? If that's what you want, include it in your agreement. You have to include that in your agreement because again, that's not an automatic. And parents think that that's an automatic. It's not an automatic. It's not. There's some things that might be pretty standard and should be expected. That's not one of them. I'm sorry if that's not what you want to hear, but that's not one of them. Some states make that a customary or usual provision in their parenting plans or agreements. Some of them don't. Some of them you have. That doesn't mean you can't add it, but some of them just don't. So you have to add it on your own. And you should definitely do that. And it should say, you know, under what circumstances should that parent reach out to the other parent to see if they can take over custody or visitation, parenting time or visitation in that specific window, in that specific time period. It should be specific. I hope I'm, you know, not complicating things, but so I'm going to go through two more. Oh, this is a good one. This is one that always comes up too. Should this always comes up, and I'm always interested to see how people with men and women, dads and moms, I'm always curious to see how people respond to this question or this issue or this topic when it comes up. When and if kids should be introduced to a girlfriend, boyfriend, paramour, live-in, new wife, blah, 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 and how. And again, that is not across the board. This is automatic, a no or an automatic. It's okay. It's a go. It's not an automatic. It's not. It's not a standard provision in all 50 states. It may be in some states, but it's not something that if any courtroom you walk in and you say that to a judge and the judge is going to be like, oh yeah, that we automatically, that's not one of them. Because again, some people think, you know, there's some social mores or norms that everybody follows about, especially when it comes to kids. Um, and so they think, oh, Johnny should not be introduced to your girlfriend right now, you know, or ever. Or your girlfriend should not be accompanying you to pick up and drop off. Or you guys should not be having outings together with Johnny because that's not his mom or his stepmom. Mm-mm. No. If you want to include that, if you want that provision, and let me just say this, let me back up a minute. Sometimes some of the provisions that you include, the ones that are not customary for your specific jurisdiction, sometimes judges or the GAL, which is the guardian ad litem or the law guardian, whatever it's called where you are, can actually say, or the forensic psychologist, or the therapeutic evaluator, the forensics evaluator, whatever, whoever is actually speaking on behalf of the child, they may say, you know what, we don't need this provision. We don't recommend it, take it out. That can happen. And if they do that, the judge will say, you know what, we're going to mark that. We're going to cross that. We're going to ixnay that. It depends. It depends. And the reason is because, like I said a minute ago, everybody's going to get a new life. Life goes on. And if you want to control and manipulate someone else's, your co-parent's social life or romantic life, guess what? It's the same rules are going to apply to you. So now you meet, you know, Harry, and now you're really digging Harry, and now you want to do things with Harry and your kids. And now guess what? You have that provision in your parenting plan, your agreement that says the same thing that goes for Peter goes for you. So there may be times with provisions like that where a judge may say, no, we're not going to include that in the order. And another provision, and this is my last one, but this one is, I don't think I've ever seen an objection to this provision from the court's perspective or the law guardian's perspective, with a caveat though. Calling a step parent mom or dad, that usually is a big no, unless the kids decide to do that on their own. You can include that in the parenting agreement. If you blanket say in the agreement that kids are not to call any other parent mom or dad, no matter what, there may be the likelihood that the judge again would strike down and say, you know what? No. Even if it's not the judge, again, GAL, forensics evaluator, the therapist involved, they may say, because they met the kids, they may say, you know what? The kids really love their stepmom or stepdad, and we don't see a problem with it. They decided to call them that on their own. It's different if a parent forces a kid to call the new stepmom or stepdad, mom or dad. That's different. No one should be forcing the kids to call anybody else mom or anybody else dad unless those other parents. There really isn't an unless, but unless either parent is no longer here, and they may, for emotional reasons or whatever, they may say to the kid, "This is your new mom." Not to erase the old mom, but this is your new mom. I personally don't like that either. But you know what? If I were a GAL and someone that was my case, I wouldn't really create too much of a problem, an issue, a fight over that. But forcing kids to call, especially a girlfriend, no, no, under no circumstances should a girlfriend or boyfriend be called mom or dad. A stepmom or a stepdad, again, if the kids decide to do that on their own, if you don't like it, then you can just you can address it. But would you really want to stop your kid from doing what they wanted to do? That's not something, and that's a question the judge, a court would ask. So I don't see any questions here. Let me see. How do I go back to the questions, comments? Oh, what happened to my comments section? Okay, I don't see any questions here. I got to get back into the swing of things. I will be back on my regularly scheduled 4 o'clock Eastern Standard Time every Thursday to discuss different topics. If you have ideas for topics, please leave a comment on my business page or in the group. You can visit my website at www.thedivorcesolutionist.com. I have blogs there. I have free resources there. I'm always adding new programs there. I just started a membership subscription-based program. So go there. I just added pro se family court coaching, in addition to the unbundled services, which is really geared for pro se litigants. I now offer pro se coaching. So I will actually coach you through your pro se family court matter. Yes, I have packages for that. I actually started a new group just for pro se litigants as well. It's called Pro Se Divorce and Custody on Facebook. So look out, go and search for that and join that as well. But yeah, I have my YouTube channel. So yeah, there's no way you cannot find me. I'm on Instagram at the Divorce Solutionist. I'm on Twitter at the same handle. LinkedIn, same handle, the Divorce Solutionist. So feel free to look me up, ask me questions, say hi, ask me my opinion about something. I'm here. There's no excuse to not find me. And I welcome, I welcome you asking, reaching out to me. I love when people reach out to me. Makes me feel good, makes me feel important. Anyway, thank you for tuning in. I look forward to seeing you next Thursday, same time, same place. Maybe same topic because I only went through a few provisions. Maybe I'll pick up next week. Anyway, until then.